Welcome to the Fleet Geeks podcast. We're here to help develop fleet and transport professionals. Do you want to progress and develop your skills and knowledge? We promise to bring lively conversation and debate around interesting issues and keep you bang up to date with changes in our awesome industry. The Fleet Geeks are a community of professionals, and if you enjoy the podcast, why not join the discussion for free in the Fleet Geek community over on Facebook. Hello and welcome to this episode of the Fleet Geeks podcast. I'm back in a Weightmans office here in Birmingham at Colmore Row, overlooking the beautiful skyline that is Birmingham. It's a bit grey and cloudy today though, sadly, but nonetheless it's sunny and bright in here because I'm joined by two superstars. Sarah Jennings, associate in the transport regulatory team. I got that second time, sorry Sarah, and I'm joined today by Jon-Paul Casati, who is a principal associate in the commercial litigation team. Jon-Paul, welcome to the podcast for the first time. Sarah, welcome back.
Thank you.
Thank you.
For introductions, please do give the listeners an introduction of who you are and what you do in the team, if that's okay. Let's go with you, Sarah.
Well, here I am again. So if you haven't heard me before, and then you're hearing me again, or if you're hearing me again, yeah, here we go. So I'm an associate in the Transport Reg team. I deal with anything that normally involves the Traffic Commissioner, anything regarding your operator's licence, public inquiries, preliminary hearings, DVSA investigations, anything that's going on, I can help you out with it.
Do you know what, Sarah? I actually think you are now the most common guest on the podcast. Actually, I think you've just beaten the record.
I think that deserves an award, doesn't it?
I think you need an award. I'm going to make you one.
Thanks.
And I'm going to give you a quality street as well to say thank you very much.
Yay.
Because it's Christmas, right? That dates the podcast, but it's all good. We are recording this just before Christmas 2024, so if you're listening, but it'll still be relevant even if you're listening in 2030, so long as commercial litigation law doesn't change. It'll be all good, right? Jon-Paul, over to you. Are you able to introduce yourself for the listeners, please?
Yeah, so I'm a principal associate in the litigation team, deal with a broad range of disputes, very similar to Sarah and her team. A lot of what I do is working with businesses and individuals to help them avoid disputes, but then representing them if disputes do arise, as they inevitably do.
Awesome. So, fantastic. So this podcast is going to be all about contractual elements of the transport industry in particular, both from a general business perspective and a specific industry perspective. So, first of all, we were going to talk about how contracts are formed, what types of contracts there are, what is, essentially legally, what is a contract, I suppose, is a good place to start.
Yeah, start at the beginning, really. So most people are aware of, the standard type of contract where two parties get together, agree some terms and conditions, sign off one document, and everything's included in one document. But what they have to be aware of, and what businesses are often unaware of, is that contracts can be formed in other ways. Many people might be aware of the idea of a verbal contract. So my word is my bond, comes from somewhere. You can agree the terms of a contract in a spoken agreement over the phone. Other ways are through a course of conduct. So if you've been doing something in a certain way for a certain period of time, it can establish a relationship which can be considered contractual, and breaching those terms and conditions, I say that in speech marks, but breaching those terms and conditions can have just as big an impact as breaching the terms of a standard contract. And the last one I wanted to mention was, and the one that a lot of people need to be aware of, is contracting on another business's standard terms and conditions. So when they send you an email with something attached, or they get you to sign a purchase order, or even present you with an invoice with something printed on the other side, it's pretty important to read those things, because those can also dictate the relationship.
Mm-hmm. Is that something you do, I suppose, is that I'm about to sign a contract with somebody, and I could just go, Jon-Paul, just being proactive here, could you just have eyes on these and then potentially dispute at a point prior to signing whether there's something that doesn't quite fit or suit me in the terms and conditions?
Yeah, you can absolutely do that, and I wish more people would do that, because we can pick up on things at an early stage, and if you get your contract right, that can eliminate a lot of disputes that arise at a later date. What can be quite difficult as a litigator, or slightly frustrating, or where I feel for my clients, is where they come to me when The proverbial has already hit the fan and they're already in litigation and they're in trouble. And I think if you'd have just come to me a couple of months ago before you signed this, I could have alerted you to this risk and you might have avoided this dispute that is now taking up all of your time.
And I don't mean to sound really stupid here, but actually I probably should have asked this up front. What does litigation mean, actually? Is that okay to ask that? I don't know if that's a really stupid question
it's
or not.
Not really, because a lot of the law firms tend to rebrand these days as dispute resolution.
Okay.
Because it probably is more accurate. I mean, litigation, we would talk, I think the idea really is once a claim's been issued at court, you're in litigation and the claim's proceeding. But so much of what we do, I'd say only probably 1 out of 10 of my instructions actually goes to court, probably actually even less. Most of it is resolving those disputes at an early stage, encouraging parties to negotiate, go to mediation, do deals and try and avoid what is a very, very stressful and expensive process, which is, the litigation process.
Brilliant. Okay, cool. So that's really useful, I think, as a starting point. And I think, so one of the things I guess I'm interested in, because I know a lot of, I suppose a lot of the people in the industry that I do business with, a lot of it is quite old school on a handshake, right? My word's my bond and all that sort of stuff. What are the risks of that? What's the challenges? How do these contracts end up in litigation? How does that work?
Yeah, I mean, there's two answers to that question really. There are some people that do business that way throughout their entire careers and never have any problems, and that might be because they're very good at their jobs. They don't make mistakes. They build relationships with the right people, and they deal with other people who are of a similar mindset. Those situations are often the most difficult to unravel, though, when they do go wrong, where you've got people in business, say, in a partnership where they've worked together for years and then they don't want to work together anymore, and it's, well, who owns this, who owns that? If you've got, to try and think of a more transport-based analogy, if you're delivering goods from one place to another, at what point does the liability lie? If something goes wrong, is it with the person who's dispatched it? Is it with the person who's transported it? Or is it the person who's receiving the goods? And if you haven't got clear terms setting out whose liability it is, it can take an awful lot of time to unpick those things. And that's where those are the sort of cases that do end up in litigation.
Got you. And I suppose become quite complex because how I understand human communication is, just because I expect one thing, it means you expect something different, and then trying to find the level playing field, even though it's been a certain way for a certain period of time, that's still a challenge. Okay, so generally a recommendation is to have some level of terms and conditions, some level of contractual agreement between. Absolutely,
yes. And certainly, the more expensive, the more important to your business the matter, the more important it is to get something hammered out properly and also have a solicitor look at it.
Okay, and I guess a general recommendation then for listeners is not to necessarily just accept the T's and C's of agreement, particularly if it's something big and expensive, because there is this tendency to just go, oh well, they do business with, and I think this is particularly tangible in our industry. Well, I've been recommended them because they've been doing business with this company, and I know they're okay, and they've been doing okay over there. So there's a just a general acceptance of, okay, we'll just do the T's and C's because that's what they have in force generally. What are your thoughts on that as a risk?
Yeah, no, it's completely the same, and it's also just, we can't get away from the business realities that people who are often making the decisions on behalf of the business are busy people and they want to do their job, and they haven't got time to read all of the terms and conditions that are printed over leaf or attached to an email, sometimes in very small print. But it's really important to be aware that it's not the same as in a consumer position where you've got all sorts of rights that protect you. If you're two businesses entering into an agreement, you're deemed to have agreed of your own free will and be aware of what's in the contract and be bound by that. There are exceptions from that, but if you're going to try and argue that you didn't sign up to something which you clearly have, or there's a clear paper trail showing you have, then you're really facing a bit of an uphill battle to win that argument. So
I think it's about empowerment as well a bit, isn't it? And I know that might sound a bit, whatever, but it's feeling empowered to go to the bigger company, if you are the smaller company, and say, actually, I don't agree with that, or we can't actually make that work. And asking them if there is any room for manoeuvre on T's and C's, and sometimes, okay, the answer might be no. If they're exceptionally big outfit and their lawyers have already drafted it and it's our terms prevail, which we know often is the case, fine. But often if you are kind of similar sized businesses and things like that, then I think it's having that feeling empowered enough to say, actually, I don't agree with that, or we can't do that, we can't make that work, so can I change this aspect of the T's and C's or the agreement so that it comes in both our favours, and it's sometimes just making it equal as opposed to one-sided, isn't it, rather than anything else.
And absolutely, and even in the analogy of the large company contracting with a small company, depending on how you do that negotiation, if you come back and pick up something in the contract you're not happy with, you're actually showing that you're quite on the ball. So you might actually impress the other party, more so than if you just blindly sign up to things.
Exactly. And
I suppose naturally a company will always have T's and C's that are designed to serve their business, right? That's like that's naturally part of the process, right? So with particularly listeners, so the listeners are in transport, fleet operations, those kinds of things. I'm thinking about the types of contracts they go into. So there might be financial agreements, hire purchase agreements, those kinds of things. We have contract hire, which then might involve an element of service delivery around maintenance. So what we call R&M, or repair and maintain vehicles. Warranties, we also, I suppose, see the actual carrying out of the work, so the delivery or certainly third-party elements of doing work for other people. What I guess are the risks? Where do the disputes come up? What is it what is it that we're looking out for there? And
Disputes come down to a few broad headings. Delay is often one. If you promise to do something by a certain time and you don't do it, because that has knock-on effects to the other party's business. Lack of quality of goods and services, whether what you're providing is fit for purpose for that other business. And then, of course, there's cold hard cash, people not paying, and you having to chase up those debts. And quite often the non-payment's linked to one of those previous factors. Someone's not paying because there's been a delay, and then you've got to go back to the contracts and say, well, what did we actually say? What did we agree? When did I say I was going to deliver this for you? When I'm maintaining and repairing your vehicles, what are the standards I said I'd adhere to, and have I met those standards?
And I think that is very important for operators, because that's when I would question, and I do question clients quite a lot, to say, you might have this in place, but have you thought about, introducing an SLA or something with your maintenance provider to specify exactly what you want them to do? Because whilst you might have some overriding T's and C's that are just quite generic, you can also get an SLA in place that might say specifically, I require a laden brake test at every PMI, and that's what I require to me, Joe Bloggs Limited, and other people might not require that. So actually, in the overarching T's and C's, the garage are not going to do that. But if you want that, then you need to be specific. So that's where it's important as well, and you might need to get some advice on that, and you might be with main dealers and they might go, no chance, we're not doing it, or something like that. And again, it's that kind of empowerment to push and say, no, we need this, we're prepared to pay more for it, but we need this, so we need another agreement in place which specifies that. And
this is one of the challenges. One of the challenges in the industry is, so the best practice guidance, so guide to maintaining roadworthiness as an example, if we deal with maintenance, on the maintenance side of stuff. So if I'm buying from even Scania, Volvo, whoever it may be, one of the vehicle manufacturers, and I take a vehicle under warranty with a maintenance contract, and we talk there about requiring laden brake tests, for example, right? Now, the guidance has changed. Some companies will sign into a 5-year agreement with those companies, but what happens when the goalposts move, right?
Exactly, and it changes so quickly, Pete. We see that, don't we? We see updates all the time. We've seen the most recent update is going to update again. It will probably update again after that we don't know about yet, that hasn't come into conversation. But that's where it's important as well. And I think it's having those open conversations, having a channel or an available email address or someone to speak with at those businesses to voice any concerns that you have as well about what you've signed up to, and to see if there's any negotiation about what happens now.
Yeah, absolutely.
Hello, it's Shani from Flagship Partners. We are really proud to sponsor the Fleet Geeks podcast. If you need expert advice or training for your fleet business, make Flagship Partners your first choice. We are really excited to announce the launch of our Transport Manager Academy with expert development for fleet leaders, We offer fully accredited initial transport manager CPC training, CPC refresher, and operator license awareness training, as well as mentoring, support, and professional development beyond the qualification. Our vision is to develop elite fleet professionals.
So, Jon-Paul, I'm assuming there's often you get involved when there's been these challenges and there's a dispute around delay, poor quality, non-payment, for example. What are the consequences for a company? Where does this go from a stress, time, cost perspective?
Yeah, absolutely. Litigation can be incredibly stressful and time-consuming, like you say. It is, where you can, you should try to avoid or settle litigation. I mean, it's a strange thing for me to say because I make my living out of litigation, but I spend most of my time telling people not to litigate because it's in their best interest to try and settle. There are some times where it is just unavoidable. You just have to draw that line in the sand, or you do have to fight your corner. But when you do enter into that litigation, certainly into the court system, what you can expect is a lot of costs. It's expensive, even if you're not instructing solicitors and trying to do it yourself, which I wouldn't necessarily recommend. You've got court fees, but you also your business time that it takes up, taking you out of the business, taking you away from what you want to do. The stress levels, which just can't be underestimated. You're talking about putting documents together, putting witness statements together, attending a hearing which might go on for a couple of days, potentially instructing experts, and it really can take over your lives, and you'd rather be doing something else.
And these things take a really long time as well to get to court, don't they, in the end? So you're not talking like Traffic Commission Public Inquiry, which wraps up in 6 weeks. We're talking like 6 years sometimes, aren't we?
It can go on that long. I'd say more likely to say maybe 18 months, 2 years from start to finish. But the more complex ones can go on that long, definitely.
All whilst you're trying to manage your transport operation and making sure that you stay compliant on every other level as well.
Yeah. I can't think of anything more stressful than something lasting that long.
Yeah.
I think I know this isn't related to litigation, but from the operator licensing perspective, people always go, oh shit, I've only got like 2 weeks, or I've only got a month to prepare. Actually, that's quite a good thing because it's hanging over your head for a short period of time and then it's done. Could you imagine, you've got this dispute and actually, you're challenging it and it's taken 18 months, 2 years of stress and heartache and pain and the bitterness and challenge, I suppose. I bet you, I imagine, Jon-Paul, you deal with some really bitter, frustrated, upset people, right?
Yeah, absolutely. And it's horrible. And I'm sure, in the industry, it's quite small sometimes. And, once you fall out with one person, you get that negative reputation or that negative publicity. And, one dispute can lead to another. And it's really quite, it can be quite horrible for some people.
So I guess to conclude this session then, Jon-Paul, tell me a bit more about what you'd look for proactively from a sales perspective, from a purchasing perspective. What can business owners do to try and avoid this pain?
Yeah, I think there's a few tips really. One is to know your contracts. First of all, have a look at what you're actually signing up to, think if anything specific you want to put in there, and just understand them. Also, the other one, educate your staff and make sure that the staff know about these contracts. So, for example, your sales staff. So we sometimes have businesses ask us to come in, deliver a bit of training to the sales staff so that they don't fall into traps. Like we're going back to the beginning of this podcast where I was talking about verbal agreements or standard terms and conditions being slipped in with an invoice, those types of things. Be aware of those things. Also, just the human side of your business. Build relationships with the people you're doing work with, if it's possible. I know we often contract now at distance and online and all that, but if you have a good relationship with the people you're working with, the other parties to the contract, then you might be able to settle these things more quickly. You might be able to be a bit more sensible and try and avoid getting the lawyers involved. But where you do need the lawyers, what I would advise is getting people in early. Don't wait until you're in the litigation system and then ask us to help, because then you're kind of fighting an uphill battle before we even started. Try and get us in and we can start to advise about options you might not have thought about in terms of settlements, like mediation, negotiations, offers to settle and the best way to put them and where to pitch them, and just advise on the risks. Sometimes people need to be told, you're probably going to lose this, you're better off paying it. Other times, and I don't always want to seem negative, sometimes you really do need to litigate and you do need to issue that claim, or you do need to defend a claim against you, and we're more than happy to do that, and fight your corner all the way if we need to.
Awesome. So we're back to proactive, not reactive.
We are. We're good at that, We're good at that.
I love it. Sarah, Jon-Paul, thank you very much for joining me today.
It's
been really, really insightful, really interesting podcast, so thank you very much. Appreciate you joining me, and it's been a pleasure to come and visit Weightmans on this fine day just before Christmas to record a few podcasts and look at the Birmingham skyline.
Oh, don't be a stranger yet.
Yeah, looking forward to it. I'm looking forward. We're going for we might be popping for a Christmas drink before I disappear back to Peterborough.
We most definitely
Non-alcoholic, of course, non-alcoholic. Right then, it's been a pleasure. Thank you very much, guys, and see you on the next podcast. Listeners, please do subscribe, share, and drop any comments in the feedback. It'd be great to hear from you. Thank you very much.
I hope you enjoyed today's episode. If you did, please share with your friends and colleagues too. Join us for free on Facebook with the Fleet Geeks community for transport and fleet managers. Fleet Geeks offers ongoing professional development, networking and mentoring too. So get in touch with me, Pete Rushmer, on any social media platform to find out more.